Objection! I direct you not to answer that question. How many of you know the two instances where an attorney in a medical malpractice case is ethically can go ahead and tell their client not to answer that question? Anybody know? This is interactive, by the way. The first question is where it calls for privileged communication, where the attorney wants to know what the client said to you, the attorney. That, I can go ahead and say, do not answer that question during a deposition. What's the other question? That I'm legally and ethically allowed to tell a client not to answer a question. Anybody? That would be when the question is palpably improper, such as, hey, Mr. Jones, how many times do you beat your wife each night in a medical malpractice case? Objection, that's palpably improper. Don't answer that question. So what does that have to do with medical malpractice? Actually, it's just the introduction to what you're going to learn in today's discussion, because anybody here, by the way, handle medical malpractice cases or PI cases? Excellent. So what you're going to learn in today's discussion, I guarantee you, will help you throughout the course of your career. Because no matter whether you handle real estate transactions, or trusts and estates, or regulatory issues, or transactional matters, it doesn't matter what. I guarantee you that during the course of your career, you will encounter people who tell you a tale of woe. And you're going to get the sense in your mind that maybe, just maybe, this person might have a claim against their doctor or a careless hospital. And now you have an obligation to say to yourself, what can I do as an attorney to help this person? So that's today's discussion. So now let me ask you this question. Let's say you are a real estate attorney and a young couple comes to you to go ahead and do their closing. And now a month later the closing comes up, and guess what? You show up, the wife is there. Where's your husband? He's not here. He had a massive heart attack. He's in the hospital recuperating in the intensive care unit. And now as you begin to ask questions, it turns out that the wife is telling you the husband made complaints of problems and chest pain months earlier. And she starts telling you about problems that he would continue to make to his cardiologist. And you get the sense from talking to her that maybe, just maybe, there may be a case of medical malpractice here. And now the question you're thinking is, I'm a real estate attorney. What do I know about medical malpractice? What do I care? Why can't I just tell them, you know what, go find a med mal attorney on your own. I don't want anything to do with it. Well, you could do that, but I'm going to suggest an alternative. I'm going to suggest that maybe you might be able to help them, or at least guide them until you reach a decision about what's best for them to do next. How about this scenario? Let's say you're a trust and estates attorney, and now you're called to the hospital to learn to do a last will and testament. There's a young woman who's dying. She's 40 years old, and the distraught husband calls you and says, please, you've got to come and do a will for my wife. And now you go to the hospital, and it turns out, what happened? It turns out that asking questions for the purposes of the will, you learn that this woman is now suffering and dying from advanced metastatic breast cancer, stage 4. And while you're talking to the family, you get the sense that maybe something was missed. Why? Because a year and a half earlier, she had complained to her gynecologist about a lump in her breast, and the gynecologist told her, don't worry, we'll just watch it. And that was over multiple visits. And you get the sense that maybe somebody dropped the ball, and that if they had recognized this earlier, this young woman and her family would have been able to get treatment earlier, would have been able to catch this cancer at an earlier stage, and she wouldn't be dying right now. So what can you do? What do you do in that instance? You say, hey, wait a second, I do trust and estates. I don't know anything about medical malpractice. Why should I do anything or make the effort to try and help these people? Well, I'm going to suggest that although you don't have a legal obligation to help them, I would suggest that you have maybe an ethical or moral one. And I would suggest also that by helping them, you become the go-to resource for all things legal, because now they're looking to you for help, not just with the estate planning, but with everything else. So let me give you another scenario. Let's say you do workers' comp, right? And now a client comes to you, they got injured on the job. They were injured in a forklift accident. And everything's going fine until 8 weeks later, the client comes back to your office to fill out some paperwork, and he tells you, listen, I think I have to sue the hospital. And you're wondering why. He said, well, the cast that they put on when I fractured my arm, They just took the cast off. And look at it. It looks like a freaking roller coaster. They set my arm wrong. But you're a workers' comp attorney. Do you say go find somebody on your own? Or do you say, you know what, let me ask you some questions. I think I might be able to help. So again, ask yourself these questions as we go through this morning's discussion, because I guarantee you, whether you're standing online at Starbucks getting your morning coffee, whether you're at your kid's soccer game or at a swim meet, you will encounter people just by having small talk who all of a sudden start telling you their tale of woe, and you're going to get the sense, hey, maybe something was done wrong, and now the question for you is, what do you do about it? What can you do about it? So this morning's discussion is about medical malpractice. Well, let's start at the beginning, the most basic thing. What is medical malpractice? It's really nothing more than medical negligence, medical carelessness, the carelessness of a physician, right? We like to say that there's a departure from good and accepted medical care, or a violation from the basic standards of medical care. That's what it is. Okay, but we're attorneys in this room. What do we need to make out a prima facie case to prove a case? Well, we need liability, causation, and damages. All right, that's nice and theoretical, but that doesn't help us. What about this scenario? What about explaining it this way? We need to show that the doctor was careless. We need to show that the carelessness was a cause, it doesn't have to be the cause, of the injury, and we need to show that the injury is significant and or permanent. Those are the three things that we need to make out a prima facie case of medical malpractice. But you should know something else. In order to go ahead and bring a lawsuit in New York, we are required to have a medical expert go ahead and review all of the patient's records to confirm each one of those three elements: liability, causation, and damages. If our expert cannot give us that confirmation, we can't go forward with the case. So the law requires us to have a medical expert. And you're going to hear a little bit later on that there's only one instance, one situation in which we will not need and will not require a medical expert. But I'll get to that later. Okay, so now you're chatting with somebody. Maybe you have a problem with your computer. You work in a big firm, and you call up the IT department, and they come and fix your computer. And you make some small talk with the guy fixing your computer. And you say, hey, how's it going? And he decides to answer you truthfully and tell you, oh my God, this is horrible. I just had a horrible situation. My father just died. He went into the hospital for a urological procedure, and now that went great, but 2 days later he was dead from a massive stroke. And you start to ask questions. But you make the mistake of saying, tell me what happened. And I'm going to suggest to you, absolutely under no circumstance are you to ask that open-ended question. Because the moment you do that in your kind and gentle way, you are opening the door to allow this person to go ahead and go on for a long-winded narrative that's going to go on from 45 minutes to an hour. And it will be just like you are in law school again, or sitting for the bar exam, trying to sift through the facts that are important and the issues that are important. And you don't want to do that. There's a better alternative. Would you like to know what it is? The alternative is to ask a single question. It's a compound question. It's one that calls for multiple answers within the same question. And I'll tell you what I mean. So instead of turning around and saying, hey, tell me what happened, as if you're doing a consultation and now the client gives you a long-winded narrative that goes on forever, what I suggest you do is to ask, what do you think was done wrong, and what injury did you suffer as a result of that? Contained within that one question are the three elements that we need to evaluate whether or not there may be a valid basis for a case. What do you think was done wrong? In almost every instance, the injured patient will be able to tell you, at least most of the time, what they think was done wrong. But then the second part of the question stops them cold, because they're not focused on the link, the causation, the bridge between the wrongdoing and the injury. Why? Because they don't know what is needed to prove a case. So when you ask that question, they'll tell you what was done wrong, but then they'll stop and say, wait a second, did that cause the injury? I don't know if it caused the injury. And now they'll have hesitation. And that's natural. So don't expect them to know the answer, but they will always know what injury or damages they have. And then you, as the attorney, may be able to put the pieces of the puzzle together and connect the dots. But that quick question, in just the first few moments of talking to them, will give you a sense of what type of case this may be and what type of damages and injuries this person may have. So now you're on the path to learning great information and what you need to know. All right, what else do you need to know? The most important thing for you in talking to this person for a few moments is to know whether or not, what? Whether the matter is timely. Because if it's not timely, guess what? It doesn't matter how horrible the medical care was. It doesn't matter what injuries they suffered. It could be the worst injuries in the world. If the matter's not timely, there's nothing you or I or anybody else can do. So this morning's discussion is going to explore a great deal about when are these cases timely and what you need to know to help them make an educated decision about what to do next. Okay. Does anybody here know what the time limit is for an adult to bring a lawsuit against a private doctor or a private hospital? Shout it out if you know. Come on, it's early, but not that early. Anybody?
2 years. 2.5 years.
2.5 years, correct. All right. What is the time limit for an adult to bring a lawsuit against a municipal hospital like Bellevue Hospital, Metropolitan Hospital, Jacobi Hospital, Elmhurst Hospital? Anybody know? Yell it out.
1 year?
Close. What is it? Say it again. Close. In a municipality, we are required first, before filing a lawsuit, to file a notice of claim. You have 90 days from the date of the wrongdoing in which to put the municipality on notice that there's a lawsuit coming down the road. And then you have only 1 year and 90 days from the date of the wrongdoing in which to file a lawsuit. But these are the general principles of how much time somebody has. And in law, you know that there are exceptions to every single rule. There are exceptions for children. There are exceptions for municipal hospitals, state hospitals. How about this scenario? Let's say someone dies at a private hospital in New York. How much time does the surviving family have to bring a lawsuit? Shout it out. Guess. Doesn't matter. Anybody? 2 years. Okay. But now let's turn it around to a municipal hospital. How much time does that same family have to bring a lawsuit against Bellevue Hospital? It's not 2 years. You have 90 days from the date of the wrongdoing and 1 year and 90 days from the date of the wrongdoing to file a lawsuit against the municipality. Very, very different and very important. So that's the first question you need to ask when you're talking to this person. But before you ask, when did this happen? You should be asking, where did this happen? And I don't just mean New York. I mean, was it in a private hospital? Was it in a private doctor's office? Was it in a municipal hospital? Because why? Why do you need to know that? Because the time limit is different for each and every location. And if you know at the very beginning that their matter's not timely, I'm sorry, politely tell them that you can't help them. All right, so let's say you get past that. You now are dealing with an adult. You now are dealing with a private hospital. You now know the time limit for wrongful death. And now you know the time limit for wrongful death in a municipality, municipal hospital. What about this scenario? What about mom and dad who are having their very first baby? Mom is pregnant. She goes to the hospital to deliver a baby. During the course of labor and delivery, the nurses and the doctors fail to recognize that the baby is in distress and having significant lack of oxygen, deprivation of oxygen. And they don't realize it in time. And by the time the child is delivered, the child is born with seizures, sent to the neonatal intensive care unit, and is ultimately diagnosed with a condition called hypoxic ischemic encephalopathy, which means there's been a severe lack of oxygen and blood to the baby's brain, causing significant and permanent brain damage. And now the family is looking to see whether or not they can bring a lawsuit against the hospital. So let's say this is a private hospital in New York. How much time do mom and dad have to bring a lawsuit on behalf of their injured baby? Take a guess. Anybody? Going once, going twice. Nope. Anybody else? The answer is 10 years. 10 years from the date of birth in which to bring a lawsuit for a brain-injured baby that occurred at the time of birth. But what if this scenario happened in a municipal hospital, like Elmhurst Hospital or Kings County Hospital? How much time does the family have? 90 days from the date of the wrongdoing, 1 year and 90 days from the date of the wrongdoing. Dramatically different time periods. So now what happens, though, if the family comes to you and they're chatting with you, and it's now 6 months after the baby was born, in a municipal hospital, for example? Is there a way to go ahead and still file that notice of claim late? The answer is yes, there is. There is a procedure to do that. But it's a very involved procedure that begins with getting all of the medical records, going ahead and having a medical expert review those records, and then getting confirmation that there's a valid basis for a case. Then we have to petition the court for special permission to apply for a late notice of claim. And in doing that, we have to tell the court, hey, look, our medical expert is submitting an affidavit or an affirmation, and here are the specific reasons what they did wrong and how this baby suffered injury. But that's not all. We also have to show how the hospital is not prejudiced by filing this late. And we are not always successful doing that. And depending upon the length of time that has gone by, the court may say, no, we're not allowing it, which means you have no case. Some instances, the court will allow it. So it's a very detailed process that we prefer not to be in, if we can help it, but may have no choice to try. All right, so now you know what happens in a baby case. What happens in this scenario? We call this foreign objects. Let's say you go in to have a surgical procedure done, and lo and behold, a couple of years later, you learn that a doctor left a clamp inside of you, a surgical clamp, or a lap sponge, or something that was never intended to remain inside of you. These are foreign objects. I don't mean aliens, but I mean something that should not be inside of you. How much time does the injured patient have to bring a lawsuit at that point? Anybody know?
2.5 years from either discovery of the device or when you should have known.
Close. And that's going to apply to a failure to diagnose cancer case, which is brand new this year. But let me get back to this because that's close. Okay? We have a date of discovery rule, which is what you were referring to. So in New York, you have 1 year from the date of discovering this foreign object in which to bring a lawsuit, or, pay attention to this, when you reasonably should have known that this object existed in you. That little addition makes a huge difference, and I'll tell you why in a minute. Okay, so you've got 1 year from the date of discovering it. But before you can know for sure whether or not this person's case involving a foreign object is timely, we have to ask one other question. And the one question we have to ask is, was this device, this thing that was inside of you that was found, was this something that was intended to remain inside of you? Or was this something that never, ever should have been left inside? Very important, and I'm going to give you an example which should illustrate exactly what I'm talking about. So this young couple, they're in their late 20s, recently married, have been trying to get pregnant for a while. They can't. So they decide to go for fertility testing. And it turns out that the wife, everything's working with the wife. The husband is the problem. What's the problem? The tube that takes the sperm from the testicles up and out has been closed off. And the doctors who are evaluating him asked him, have you ever had surgery before? He said, yeah, when I was a kid, like 7 or 8 years old, I had surgery because my testicle twisted. It's called a testicular torsion. And I had to have surgery to untwist it. And to make sure it didn't happen again, the doctor had to put a stitch in to make sure it was tied up against my scrotum. He said, that's the problem. The problem was that the doctor who put that stitch in didn't simply attach it to the scrotum, which is where it would have been fine, but he closed off that tube that allows the sperm to go from the testicle up and out. Okay, so now he decides to bring a lawsuit against the doctor or the doctor's estate. It's been a long time. It's been, since he was 7. He's now 27, 28. And now the defense turns around and says, listen, we're sorry for what happened, but you're untimely. So let's answer the question. Let's ask the question first. Was this thing that was left inside of him something that was intended to remain inside, or was this something that never, ever should have been left in? It's a stitch that was put in to hold something to another piece of an organ, right? That was intended, which means that if he were an adult, and he wasn't, but he was a child, but for the moment, if he were an adult, he would have 2.5 years from the date of the malpractice in which to bring a lawsuit. That's different than the date of discovery. And unfortunately for him, he was way past the age of majority, which is when it normally would have been extended to as a child. And it was many years beyond that. So the court says, sorry, your case is not timely, and they dismiss the case. But let me share with you another scenario where this device, or something left inside, turned out to have the opposite effect. And before I get to that, I want to address the thing that you mentioned earlier. So in January of this year, the legislature finally, after decades of lobbying, they finally changed the time limit to bring a lawsuit for patients involved in claims of failure to diagnose cancer. In a failure to diagnose cancer case, typically you have 2.5 years from the date of the malpractice to bring a lawsuit against a private doctor in a private hospital. And if it's municipal, you know what the time is, right? 90 days from the date of the wrongdoing, and 1 year and 90 days to file your lawsuit. Okay. There was a woman named Laverne Wilkinson. Laverne died as a result of improperly diagnosed cancer at a municipal hospital. Her family decided to bring a lawsuit, or tried to bring a lawsuit against the municipal hospital, but had no luck because they were way beyond the time limit. So on her family's behalf, there was a great deal of lobbying designed to try and change the inequity associated with the fact that many patients and many families don't realize until way later that somebody now has advanced cancer, and they should have picked it up much earlier. And if they had, none of this would be occurring. So now we have a date of discovery rule, which says that if you have cancer and you believe your doctor or hospital staff failed to timely recognize it, guess what? Now, you have 2.5 years from the date of discovering it within which to bring a lawsuit against a private doctor or private hospital. But that only extends for 7 years from the date of the wrongdoing. Okay, so the law allows us some leeway, saying, hey, the maximum cutoff time is 7 years. So now what happens in a municipal hospital where there's a failure to diagnose? Do you still get the benefit of that discovery rule? The answer now is yes, which is a great thing, but we all know what the time frame is for municipalities. You still, from the date of discovery, you have only 90 days from the date of discovering it, or when you reasonably should have recognized it. And then you have 1 year and 90 days to file suit. So that helps benefit these injured patients because of only failure to diagnose cancer cases. All right. But there's another scenario that I want to talk to you about. What happens if, let's say, a woman makes a complaint of a breast lump to her gynecologist? And the gynecologist said, listen, I want you to come back every 6 months. We'll check it. We'll make sure everything's fine. And she does. And in between those visits, the woman is also making other complaints unrelated to the breast lump because that tends to go away. She forgets about it. The doctor forgets about it. And she's got other GYN issues that the doctor is addressing. And now, 3 years go by. Now, all of a sudden, this breast lump comes back with a vengeance. Now there's discharge coming from her nipple. Now the nipple is painful. Now she's got a massive breast lump and it's growing daily. She goes back to the gynecologist, and now it's an emergency. Now she gets a sono, a mammogram. She goes to a breast surgeon. They do a biopsy, and what do you think the result is? She's got advanced breast cancer. And now the question is there a gap of time? Does that allow her still to get the benefit of what we call continuous treatment? Because if you continue to see and treat with the same doctor for the same problem that you originally went to them for, you will get the benefit of extending, we call it tolling the statute, of extending the time limit in which you have to go ahead and file your case. But what happens if you've got gaps of time where now you're treating with a doctor for something unrelated? Can you go ahead and still get that benefit? The answer is maybe yes and maybe no. There is no possible way for you to know definitively while talking to someone, even on the first, second, or third visit, whether or not they will be able to get the benefit of continuous treatment. Why? Because in order to truly know whether or not they have continuous treatment, we have to obtain all their records, and we have to scour every single page of every single visit to learn why they came back. Was there an expectation by the doctor that you were going to continue treating for that same problem? Why did the patient return? What was the doctor's expectation? What did the doctor intend? Who initiated the visit? So all of these details are critical to understanding whether or not, even though there may be huge gaps of time where the patient isn't seeing the doctor, or other intervening things are occurring at the doctor's office, that would allow continuous treatment. And here's a case that came down last year, which was very interesting on this topic. It says, in Hill versus New York City Health and Hospitals Corporation, it says the key issue in the case is whether a patient who appeared for a planned appointment without receiving any treatment represents continuous treatment to satisfy the continuous treatment doctrine. Think about that. The patient shows up for a visit, no treatment is rendered. How many of you think that the patient got the benefit of continuous treatment? By show of hands. Come on, it's early. Yes? How many of you think that the patient did not? All right, here's what the court said. The lower court said, no, they dismissed the claim. The appellate court turned around and says, no, 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 we're reversing. Why? Because since the patient and the hospital still had an ongoing relationship that was intended to continue forward, continuous treatment was present and the claim was timely. How remarkable is that? The doctor didn't actually render treatment on that date, but for the purposes of their relationship, they said, yes, there is an ongoing relationship, and they allowed her to go ahead and continue with her case, which is remarkable, and that's something that we haven't seen in a long, long time. Okay, so what else do you need to know? You need to know that a lot of doctors, when they are sued, they come up with 4 typical defenses. And what are they? The first defense is they say, hey, why are you suing me? I did nothing wrong. The second defense was, if I did something wrong, so did you, Mr. Patient. The third defense is, hey, if I did something wrong and so did you, whatever I did didn't cause or contribute to your injury. And then as a fourth defense, they say, you know what? If I did something wrong and you did too, and I caused you harm, your harm isn't that bad. So they try and minimize the injuries. Another common defense that often we see in these cases is that the doctor says, listen, I didn't depart from good and accepted medical care. I didn't violate the standard of care. Instead, I used my best medical judgment about what treatment to offer this patient. And you know what? That's a very compelling argument. Because who are we to argue with a doctor who's choosing among different options available, and the juries like that argument? So how do we get around it? Well, it's not a matter of getting around it. It's a matter of showing the jury that the options that the doctor had deviated, and the one that he chose deviated from the standard of care. Now, why is that a big deal? It's a big deal because let's say you go to 5 different doctors, 4 of whom say, I would do the procedure that way. The 5th one says, I'd do it that way. Now, he's in the minority. The patient decides to go with that doctor. And lo and behold, the patient suffers an injury. And she sues the doctor. And the doctor says, hey, yes, I'm in the minority, but it's still acceptable to do what I did. And you know what? That's absolutely true. As long as the decision to do that particular procedure or treatment is within acceptable standards, we don't have a leg to stand on. But if it turns out that the doctor violated from the standard of care by choosing that option, now we've got a strong case. And let me illustrate that very vividly in a case that I handled involving a gentleman who was having difficulty urinating. So he goes to his urologist, and he's a young man, 37 years old, and the urologist recognizes that he has scar tissue in the tube that takes the urine from his kidneys out up through the penis called the urethra. And so in order to get rid of the scar tissue, the doctor has to go in with a knife and literally dig it out. It's called a cold knife urethrotomy. And it is as painful as it sounds. There's no anesthesia. All right, so this works for a couple of weeks, but it's a Band-Aid. And now the patient comes back in because now there's a restriction, there's a constriction again. The scar tissue has come back. And the doctor does the procedure again. And it works again for a couple of weeks, but then it comes right back. And the doctor says, you know what? There's a way to deal with this, a better option. I'm going to take you to the hospital, put you under anesthesia, and we're going to put into your body, into your urethra, a metal stent, a mesh stent. It's a coiled metal device that we snake it through your urethra, and it's spring-loaded, so it opens up with the intention of keeping this tube open to allow the urine to pass through. This is designed to be permanent, so that once it's opened up, over time, the tissues, the skin tissue inside the urethra, it's called epithelial cells, they grow over and it becomes embedded in this tube. And the patient says, fine, just do something. So that's what happens. Now during the procedure, the doctor puts in this stent and he puts it in the back towards the end of the urethra. And he says, you know what? I'm going to put in a second one, back to back. I think that'll be fine. So that's what he does. So now the patient goes home, and you know what? This stent, this device, works. But the problem is now there's urine coming out. He can't stop it. Okay, that can be dealt with. The doctor gave him some medication to try and slow it down and stop. And that worked. There was one problem, though, and it was a significant problem. The problem was that every morning when this gentleman woke up, he had an erection to go to the bathroom. And not only did he have the intention and desire to go to the bathroom, but every time he maintained an erection, he was in the most agonizing, excruciating, horrendous amount of pain he had ever been in his life. And this was happening on a daily basis. He goes back to the doctor crying, in pain. He said, doctor, you got to do something. I literally want to kill myself. And I don't say that lightly because multiple times he told the doctor this, that he was contemplating suicide because of how horrible and terrible this pain was. And the doctor has it all through his notes. And the doctor says to him, okay, you know what? Maybe it's hitting the nerve at the back of the urethra. Let's take you back into the hospital. I'm going to move this, manipulate these two stents, and see if that gives you any relief. Patient says, you got to do something. So what does he do? He puts him under anesthesia. And remember what I said, that this device was intended to be what? Permanent. You have the epithelial cells growing over. This becomes embedded. This doctor now attempts to manipulate this stent, which is now firmly affixed to the inner tube, and starts pulling and tugging, and nothing's happening. So he pulls and tugs a bit more, and now all of a sudden the stent starts to shred. And now he's pulling out these metal wires. And at the same time he's pulling them out and destroying the stent, he's destroying the inside of this man's urethra, piece by piece. This was horrendous. After the this procedure is done, he tells the patient, you need to see a reconstructive urological surgeon immediately. He goes to a reconstructive urological surgeon who takes one look at him inside and says, oh my God, I've never seen this in my entire career. It looks like a bomb went off. Who the hell did this to you? He needed 18 months worth of massive urological reconstructive surgery where they had to construct his entire urethra and penis. It was devastating. All right, so why do I tell you this story? I tell you this awful, awful tragedy because, for two reasons. One, to determine whether or not this matter was timely. And two, to talk about whether this was a judgment call. So let's ask the question. You hear this story, you're standing at Starbucks and this guy tells you his whole life story in 2 minutes. And now you ask the question, was this device intended to remain inside of you? And he says, yes. So now you're thinking, okay, I know how much time you have. You have 2.5 years from the date of the wrongdoing in which to bring a lawsuit. And for him, thankfully, he was timely. But now let's look at the question of whether or not, when we sued this doctor, whether his claim that this was a judgment call stood up. Because if it did, we had no case. So doing the research and speaking with our experts, what did we learn? We learned that the use of this device is medically acceptable for this condition. However, here's the big however, or what we say is a caveat. This device is only to be used in elderly patients, elderly men, above the age of 65 or 70 who no longer have the ability to maintain an erection. Because the studies have proven that if you insert this into patients who still have the ability to maintain an erection, they will suffer agonizing, horrendous, horrible pain. as a result of these stents. So what were we able to show? That this doctor's claim that this was a judgment call was absolute garbage. And in fact, his decision to use these devices in a 37-year-old patient was a clear departure, a clear violation from the standard of care. That's why I use this story to illustrate that argument to you. So now you're talking to the patient. You say, hey, wait a second. I don't know about these medical studies, and that's okay. You don't need to. But I just share it with you because these defenses arise all the time, and it's compelling. But we have to ask the question, was this really a judgment call amongst other valid options, or was this something that never should have happened? All right, so now, I'm sure you all know this, but I'm going to tell you anyway. The mere fact that a patient gets a bad outcome or a bad result does not mean that there's malpractice. And the patient doesn't understand that. When we tell them that, they don't recognize that if they truly believe that the doctor did something wrong. They say, no, I went into the hospital fine, and now something happened, must have happened, and now I can't walk. Well, maybe, but then again, maybe not. But the moment you tell them that, they get all defensive. They say, what do you mean? Something must have happened. Maybe yes, maybe no. But the mere fact that they had an untoward result or not a perfect result does not mean necessarily that there's malpractice. All right. If somebody comes to you and says, the doctor didn't tell me that I could suffer all of these problems, I want to sue him for lack of informed consent. Why? Because had I known, had the doctor really told me what the risk was of getting this complication, I never, ever would have had this problem. You know what? I'm going to suggest to you one thing. In every type of case involving informed consent, lack of informed consent, here's what happens. The doctor always says, of course I told the patient what the risks were. The patient almost always says, the doctor didn't tell me what the risks were. So what do you have? You have a question of fact. And when you have questions of fact, what does that mean? It means it's going to the jury. So if that's all you have a he said, she said scenario. You're the jury. I just told you the facts. Who do you believe? That's all you know. Who do you believe? The problem with that type of argument is that most jurors will believe the doctor. Why? Because they want to believe the doctor. They want to believe that these people who we put our lives and our trust into are going to do right by them. And they can't get over the fact that a doctor might do something wrong and not tell the patient about the fact that they could suffer these complications. If that's all you have when you're talking to the client, I suggest that you tell them it's not enough. You still need to be able to show that there were violations from the standard of care causing significant harm and injury. That's the only real way you can get a jury worked up and incensed about what horrible care and treatment they received. Because if all you're going with is just, hey, he didn't tell me I could suffer this, and the patient says, and the doctor says, yes, I did, you're going nowhere. Okay? So be aware of that. Those lack of informed consent cases on their own are usually not sufficient to go forward. So remember, at the beginning of my talk, I told you that we need a medical expert to confirm that we have a valid basis for a case. And I said there was only one instance in which we don't need an expert. And what instance would that be? And it's a phrase in law, it's a 3-word Latin phrase that we all know from law school.
Res ipsa loco.
Thank you. Excellent. That thing speaks for itself. Correct. That is the only time where we don't need an expert. Now you might be thinking, how does res ipsa loquitur apply in a medical malpractice case? I'll tell you how. Let's say a patient goes in for hand surgery, and they come out of surgery with their hand fixed, but they have a 3rd-degree burn on their shoulder. And they're wondering, how the hell did I get a burn on my shoulder? I went in for hand surgery. Now the patient is told, listen, during the course of surgery, something happened, the drape caught fire, and you suffered this burn. And don't laugh, it does happen. It happens from time to time. So, it turns out that during the course of the hand surgery, an instrument known as a cautery instrument designed to cut off bleeding vessels, to burn bleeding vessels, was used and inadvertently touched the drape, causing it to go up in flames. The nurses and the doctors didn't recognize it, and by the time they did and they smell the smoke and see the flames, because there's oxygen in use, so it's going to feed the flames, this guy had already suffered a 3rd-degree burn. in that instance, it's obvious to everybody what happened. You don't need to have a medical expert come in and explain that if you're going for hand surgery, you shouldn't come out with a burn to your shoulder, right? You don't, it's just common sense, common knowledge. But you will find that the best trial attorneys in New York still will go ahead and hire a medical expert to testify. Now why? Why would they need to go through the expense of doing that? I'll tell you why. Because we want to be able to show to the jury what was done incorrectly. We want to show what the proper procedures would have been to avoid this type of injury. And it gives them additional information to help them make a decision about how careless they were in causing this harm and injury. So typically the defense never turns around and says, yeah, okay, we agree, we did something wrong, we screwed up. But here's something else you need to know. In order to take advantage of this res ipsa loquitur doctrine, we have to be able to show, number one, the patient was under anesthesia. The patient was not in control of the events that were going on, that the hospital staff were. We have to be able to show that the patient did not cause or contribute to her own injuries. She's under anesthesia, she's not contributing to anything. And that the only people who had control of the scenario, of the situation, was the hospital staff. Only in that instance can we use that doctrine of res ipsa loquitur and not have a medical expert come in to testify. Okay? All right, what else do you guys need to know? When you're talking to these people and you learn their tale of woe, I want you to think in the back of your mind as you're talking to them, who are the potential defendants? Who are the people who may have caused this injury? Is it an attending physician? Is it a doctor in training known as a resident? Is it a newbie, a doctor who just graduated medical school, who now is working in their first year of residency called an internship? And by the way, in case you don't know, that is one of the worst times in July to be a patient in a hospital because you get all these newbies coming in and they are on a huge learning curve. It's true. And so they are all learning. They know very little in terms of actual clinical medicine by the time they're an intern. And so, if you happen to be a patient, July, August, September, be very careful and ask yourself, who is rendering this care? And another thing you want to ask yourself is, who's responsible here? Okay, these are all employees. What do we know about the law and employees? Well, there's got to be an employer, right? So what do we know about vicarious liability?
Respondent superior.
Very good. Thank you, sir. That's exactly right. We know that the employer is legally responsible for the acts of its employees. So now that you're being told what's happening, and now you learn that it's a nurse or a technician or a doctor in the hospital. And now you're thinking, okay, these people may be individually responsible, but who's ultimately responsible for their care and treatment? The hospital. And why is that important? Because if you only bring in to sue one of them or two of them, you might be missing some key players involved. You might be missing some deep pockets. You might be missing the real culpable parties who could actually pay if, in fact, we're able to prove our case, that we are slightly more likely right than wrong, that what was done was true. Okay? So always ask yourself, was this a professional corporation the doctor was working in? Or were they a hospital employee? And I have to tell you, the patient is not going to know these distinctions. And in all likelihood, neither will you. This takes some digging, and even then you may not know the ultimate answers to whether or not they were employed by the hospital or employed by a faculty practice or a private medical group. That takes some digging, and you should not be expected to know that, but keep that in the back of your mind. Who is actually responsible? What else do you need to know? You need to know, where's the venue? Where might we bring this case if they have a valid case? Venue is critically important. So if the patient lives in Manhattan, but the treatment happened up in the Bronx, you now have a choice of where to bring your lawsuit. And are you going to bring it in Manhattan or are you going to bring it in the Bronx? If this happened in Queens and the treatment occurred and the patient lives in Brooklyn, again, you have options. If the treatment and the patient lives in Brooklyn, guess what? It's happening in Brooklyn. This is important so that now, when you make the decision about whether or what to do with this case, what to do with this possible case, it will be helpful that if you decide to refer it out to an attorney, now you can have an educated conversation with him or her and say, listen, here's the venue that I think this case is going to take place in. And then you also should be focused on what type of witness will this person make if this case goes to trial 2 or 3 years down the road. That is critically important. Your impression of this person makes a huge difference. Why? I'll tell you why. Because if you get the sense in talking to somebody for a few moments that they are nasty, they are obnoxious, they are vengeful, how do you think they're going to appear in front of a jury 2 or 3 years down the road? You think they're really going to get that much better? You think they're now going to turn into a soft, sweet cupcake? Oh, yes, thank you so much. Unlikely. They may improve, but those first impressions are very important. Now, on the other hand, if it's an 85-year-old grandma and she's sweet as pie, again, these impressions will help you determine whether or not there may be a case, because there are attorneys that I know, myself included, who will reject a case if the client is nasty, if they're obnoxious, if they are refusing to accept legal advice, if they are antagonistic and fighting with me every step of the way. I don't care what kind of case they have. I now have to live with this person for the next 2 or 3 years. And if I know at the outset that this person is going to be trouble, there's the door, politely. Thank you, have a nice day, you better find somebody else. Okay? So those choices will come up. So that's why I ask you to keep in the back of your mind, what type of witness will this person make in front of a jury? So now, it's time for you to decide. You've learned a bit of information. You've determined that the case is still timely. Now, you begin to formulate in your own mind that this person may have a basis for a case. So what do you do at this point? Now you've got a choice. And remember what I asked you at the very beginning? I said, you can turn around and say, hey, I handle trusts and estates. I handle real estate transactions. I'm a bankruptcy attorney. I don't do any of this stuff. Go find somebody on your own. Yes, you can do that. But wouldn't it be better, wouldn't it be more helpful if you turn around and say, you know what? I now have an option. One option is I can take the case on myself. And if you're willing to do that and able to do that, fine. But just make sure you know what you're doing and have the confidence and ability to know what you're doing and what you should not do. Okay? If you choose to send the case out and refer it to an experienced med mal attorney who does this every day, I have to give you some advice about what you need to look for when you're deciding who to send it out to and where. Okay? Because this is important. So now you've made the decision in your mind, you know what, I'm going to refer it out. So before referring it out, you need to know that the attorney's fee in a med mal case is significantly different and less than in an accident case. In a typical accident case in New York, the attorney's fee is 1/3 after expenses. In a med mal case, the attorney's fee only starts at 30% and drops in increments by 5% until you reach a cap of $1.25 million. Anything above that is only 10%. So it's a sliding scale. So knowing that there's a sliding scale, typically what happens if you refer a case out is that the attorney that you send the case to, if they're successful and get money for the client, let's say they get a 20% attorney's fee. You will then get 20% of their 20%. You get a sliding scale of their sliding scale. But you should also know, there are some attorneys in New York who choose not to take a referral fee, either because of their law firm policy, or they just want to be a good person and say, you know what, for whatever reason, I don't want a fee, and that's fine. But you have to make that choice. And if you decide to accept a fee, now you have to know the other things associated with that. In order to justify getting a fee, you have to be able to show that you have done some level of legal work. Now, what exactly does that mean? Well, that's subject to interpretation, and some law firms interpret it differently than others. The fact that you meet with a client for an hour and now get all their detailed information and intake, some firms would say that's some level of legal work. If you get the patient's medical records, that may be some level of legal work. If you refer the case out and now you are kept in the loop with communications with the client and the other firm, some firms would say that is some level of legal work. If you refer the case out to another attorney, you need to make sure that when they send out their retainer, 2 things happen. One, that you are included in their retainer, which says that you assume joint representation of this client. You must do that. And 2, that they send you the paperwork to fill out for the Office of Court Administration to protect your rights, that you're now on the retainer, and that you simply sign it and drop it in the mail. Okay? So, what happens if you decide to refer a case out? The attorney says, hey, listen, we're going to take on this case. They put you on the retainer. You must get the approval of the client. So as you are about to send the client out, you must tell them, hey, listen, I'm going to send you to a law firm that handles these cases on a regular basis. I'm not qualified. I don't have enough experience doing this. Is that okay with you? They will always say yes. But I also want you to know, and you must tell them, that if you are successful and the attorney, the firm we're sending you to, gets you a good result, there is an attorney's fee that they will receive. And because I am now sending you to them, I will then be receiving a small percentage of what they receive. And in almost 100% of the time, the client will say, fine. They don't care because it's only one attorney's fee. But you must tell them. If you don't tell them, you could run into a problem later on. And it's so easy just to tell them that. And you have to ask the law firm you're talking to, hey, do you guys tell the patient, tell the injured client, listen, there's joint representation. If we get a fee, the attorney who referred us will also get a small percentage. Is that okay with you? And they will sign and acknowledge that. The moment that happens, you're fine. What happens, though, if you decide this person doesn't have a good case? Let's say it's not timely. You've come to the decision that their case, the statute of limitations has expired. What obligation do you have? Can you simply turn around and say, bye, Mrs. Jones, have a great day? No, you can't. Because once you have engaged them in conversation, and I mean more than just a brief, chat. I'm talking about once you've invited them in and spent a good deal of time with them. Now, the client may think that you are their attorney, even though you tell them, hey, goodbye, I can't help you, I can't represent you. You have an obligation at that point, and it's one you better keep in mind. And that is, you have to send them a rejection letter, a letter declining representation. Now, this letter you must send it out the following way. It must be sent out certified mail, return receipt requested, and regular mail, because you always want to make sure they get a copy, and you never want to have an issue. And contained in that letter, you must include 2 things. You need to know, Mrs. Jones, that you have a finite time to bring a case against a private hospital or private doctor in New York. You need to go ahead and speak to another attorney immediately to get another opinion. What happens if you don't add that last part in? Sometimes the client may think that you are the be-all and end-all of everything related to law, and you are the God, you are the spoken word, and if you tell me I don't have a case, then I don't have a case. Well, guess what? There may be an attorney down the street who has a different opinion, who thinks you have a valid case, who thinks it's timely, who would have taken the case had the client gone to them with time still on the statute. So what can you do to prevent a problem from occurring and getting a legal malpractice claim? You put in that letter, Mrs. Jones, I highly suggest you speak to another attorney immediately to protect your rights. That's it. Now they know that you have recommended that they speak to another attorney, and now you're good. So that's what you need to do if you are going to reject their claim. All right. We talked about opinions of witnesses, venue. We talked about what occurred to them, what you think was done wrong, and what injury occurred as a result of that. But now we're not done. Okay? This is before you make the decision to take it or refer it out. And I should have mentioned this earlier. You need to also look at damages. How badly injured was this person? Why is that important? Because they may still have a case if they have a temporary or a small injury. Maybe they fell down in the hospital and they suffered a bad bruise, and 3 weeks later the bruise heals up. And they say, yes, it was because of this person that I fell and I suffered these terrible bruises and I had to be hospitalized and I needed all these things and pain medication. Yeah, but your bruise healed up. It's not permanent. It's not significant. So what do you do then? You say, thank you very much? Absolutely. You can't afford to take on a case like that. No attorney can, because you're spending a tremendous amount of time, effort, energy, and your resources to prosecute a case, knowing full well that the likelihood of you obtaining any significant money for the client is going to be like this. Very, very small, insignificant. So in that instance, you have to ask about damages. So what kind of damages are there? Well, there are economic damages, which is financial loss to the family or to the injured patient, like lost earnings. That's easy to calculate. And we have non-economic damages, such as pain and suffering. Pain and suffering from the time of the event up until the time of trial, and from the time of trial into the foreseeable future. So now you talk to somebody and they tell you, you know what? I suffered a terrible injury where I fractured my femur in the hospital because I fell out of bed. Nobody held me in or strapped me in. I now fractured my femur. I needed to have surgery. I needed titanium rods and pins and plates and screws to hold my bones together. I was like that for 3 months. Then I needed 6 months of physical rehabilitation to teach me to walk again. And now I'm going to need another surgery to take the hardware out. You think that is a significant case? Yes, it is. So there's a huge difference when talking to these people about the type of damages they have. And now let me change tactics a little bit. What about in a wrongful death case? Okay, we've been talking about somebody who's alive and who was injured. What happens in a death case? What type of damages are available? The first thing we want to know is, was an autopsy done? And why? Because we want to know what was the cause of death. Maybe it might show, maybe it will show that something may have been done wrong. On the other hand, maybe it shows that nothing was done wrong. But we typically want to see an autopsy. If we don't have one, it's going to be much more challenging to go ahead and bring a case. With a wrongful death case, we look to see what did the patient have a conscious level of pain or suffering. If they didn't and they were unconscious, for example, I'll use the Joan Rivers scenario. Joan Rivers was under anesthesia during a procedure when the malpractice occurred. She was not conscious or aware of what was going on, which means that her family no longer had the ability to go after a claim for conscious pain and suffering, which means the biggest part of the case is gone. So what's the only thing left? In a wrongful death case, the only thing left is the pecuniary loss. What is the financial loss to the family as a result of her death? In her case, it was massive because she was earning a tremendous amount of money. So she had the ability, and her family had the ability, to obtain a very significant amount of money based on her financial loss to her family. But most people are not in that situation. Most people that wind up in this scenario don't have money, they're not working, in which case we say, what's the financial loss to the family? And most of the time, it's nothing. They weren't working. They were on Medicare or Medicaid. And now, what type of damages do you have left? Nothing, which is terribly unfortunate. But from a legal standpoint, you're not going to help this family because what's going to happen? You go ahead and try and obtain compensation from a rock. It's not going to happen. Which brings me to the question of Medicare and Medicaid. We have to deal with these agencies because once we learn that the client was elderly, now we have an obligation to notify them that this person has brought a lawsuit. And guess what? Now they're going to send us a list, line item by line item, of exactly what expenses they paid for this person's medical care that was caused all because of somebody's carelessness. And now we have to negotiate with them. And I want to tell you a story. We're coming to the end, and I'm going to tell you a story about a case that I never should have taken. And I'll tell you why we took it and why the patient got what he did. And it just so happens it's not a med mal case, but it's illustrative of the point I'm making. A young man was crossing the street in a parking lot going to lunch. He gets hit by a car entering the parking lot, and he suffers massive trauma. He's taken to a local emergency room where he is there for 3.5 weeks. It turns out this young man was somewhat disabled, had learning disability, but was working in a group home earning an hourly wage of minimum wage. So he was functional, but still disabled. The sister calls me within days of this accident happening and says, please, you've got to help me and my brother. He just suffered this horrible injury. He's in the hospital. You've got to help. So I start helping her, and I determined very quickly that the car that hit him had only $100,000 of insurance. And within days, the insurance company for the owner of the car tendered their whole policy. They said, yes, we recognize that our driver was careless. Here's the whole policy. And before I could do anything, the patient gets out of the hospital and I get the bill from the hospital, $350,000. I learn from the bill, because the sister did not know, she lived in a different state, and the injured patient was unable to communicate. I learned that Medicare and Medicaid paid for almost the entire hospital bill. So what did that mean? It meant that I now had to deal and negotiate with both Medicare and Medicaid to try and reduce the amount that they were going to recover in order for him to walk away with something. Because we would get our fee, which is a third, and now he's left with $67,000, but he's got to pay back out of his own share $350,000. Had I known that at the very beginning, I would have said politely, I cannot help you, because I don't take a case just to generate a fee. We take a case to be able to help you, to obtain compensation for the harms and losses that you suffered. So now, months and months of fighting with Medicare and Medicaid and appeals with them turn that lien into the fact that they took almost everything from him. They left him literally with just a few $1,000s. And it was really a shame. It was a shame because, again, had we known that at the beginning, we never would have taken the case. Nobody would have, because it's just not right. But at the same token, Medicare did pay for all of his hospital expenses. So there's a trade-off. So as you are talking to these people, ask yourself the question, are they elderly? Are they on Medicare, Medicaid? Did they pay for the medical bills that you encountered? If the answer is yes, you know you're going to have to negotiate with them. And now you look to see what type of damages they suffered. Are they significant enough to now offset the amount that they're going to have to repay? And again, you're not going to know the exact amount, but just have in your mind the fact that, yes, you're going to have to deal with this during the course of this case. And it's something to keep in mind. All right, so let's see what we learned this morning. If you remember, I told you, and you probably came to this class, to this discussion, saying, you know what? I'm just here at Bridge the Gap. I just need the credit. I don't care about med-mal. I don't do med-mal. There's nothing I need to know about it. But hopefully during the course of this morning's discussion, I guarantee you that during the course of your career, you will encounter people who begin to talk to you, and you'll have small talk, and you'll have conversations with people who begin to tell you their tale of woe. And now you're going to get the sense in your mind that says, you know what? Maybe, just maybe, this person has a claim against their doctor. Maybe the doctor was careless. But before you can make that decision, you know now to ask them a series of questions. Instead of asking the open-ended, tell me more, right? What are you going to ask them? That one question. What do you think was done wrong, and what injury did you suffer as a result of that? Now you have in your mind the idea of whether or not there may be a case. And before you go further, what else do you need to ask them? Where did this happen? Municipal hospital? State hospital? Where? Was it a private hospital? Private doctor's office? And then you ask the question, when did this happen? Are you an adult? Was this involving a child? Was it a baby born at birth? Is this a death action where the surviving family wants to know information? And you're thinking, I didn't need to know this. I don't care. Well, you don't. But do you have an obligation? Can you help the person you're talking to? Can you do something for them without getting any benefit or reward? And again, I suggest, as I did earlier, that the answer is yes. Not only will you feel better, but you'll be able to guide them on the path towards getting an educated answer about what to do next. What else did you learn? You learned to think about damages, and you learned to think about venue and what type of witness this person is going to make. All because you came to this class this morning, and you thought, I don't need to know any of this. And you're right, you don't. But there will be people who sit down with you. You're at the swim meet, you're at the soccer field, and now you're talking to somebody and they say, hey, you know what? Something horrible just happened. Let me tell you what happened. And just by talking to people, getting to know them, they might open up and tell you about something terrible that happened. And you say, wait a second, I think I might be able to help. And if you can't help them, at least now you know what you need to know in order to refer the case out to an attorney who does this on a regular basis. You need to think about what type of relationship you'll have. Are they going to protect your rights as the referring attorney? Will they keep you in the loop? And by the way, you should ask every firm, hey, how often do you communicate with me to update me and let me know what's going on in the case? Or do I have to nag you every 6 months or every year and say, hey, what's going on with the case I referred to you? They should have a system in place that says, I'm sending you off an email every couple of months saying, here's what's going on in the case, so that you have peace of mind, that you know that something is being done correctly. And that's important when you refer a case out, because the person you're talking to has begun to trust you. And if they're an existing client with something that you handle for them, they already trust you. And now that you're referring them out to somebody else, guess what? They're relying on you to provide them with good information. So I hope this has been useful. I hope you use this in the course of your career. And as always, if you have questions or need to refer a case, I'm available. And I hope this has been a great educational discussion. I'm Gerry Oginski. Thanks for joining me, everybody.